everyone, and welcome to Daily Newspaper Analysis, which is presented to you by Losico. So today we have two articles for the discussion. Both are from the Hindu newspaper. The first article is For Lok Adalats, Speed Overrides Quality. This article talks about the importance of Lok Adalats, but how in the current situation there has been a problem in specifically the quality of judgments that have been delivered by Lok Adalats, and what are the real problems related to them has been discussed in this article. The second one, A Way Forward for Trans Persons, talks about the rights of the transgender persons on the virtue that they have been admitted into the Chhattisgarh Police Service and that how it is a way forward for the entire community at large. And finally, we have the News in Flash column. Before moving further, let's have a look at the Project Maverick, which is almost free CLAT preparation course from Losico. So if you're preparing for CLAT 2021 or 2022, you can enroll yourself for this course just for ₹100, and you can find the link to this course in the description box below. With this, let's see what is the multiple choice question from yesterday's discussion. World Health Day is observed on. Your options are 3rd March, 1st April, 7th April, or none of the above. You can write down your answer in the comment section below. This is the descriptive question for the day. What is the significance of Lok Adalat as an institution of alternative dispute resolution? How can this system be made more efficient? So this article talks about that the first National Lok Adalat 2021 will be held on April 10. And that is why it becomes important for us to understand as to what was the entire institution and the history of bringing in the Lok Adalats in the country. So in the year 1949, Hari Vallabh Parekh, a disciple of Mahatma Gandhi, popularized them in Rangpur in Gujarat. So one thing that we need to understand here is that though the Lok Adalats were given later on, as we will see, the constitutional status via the means of the Lok Adalat Act, but it is not that, it is only through this act that the institution of Lok Adalat was introduced. Rather, Lok Adalats had existed since a very long time in the Indian society. Then, in the 1976, 42nd Constitutional Amendment Act inserted Article 39A to ensure equal justice and free legal aid to the list of directive principles and state policy. Now, as we know, that under Article 39A, which as we know now has been inserted by the 42nd Constitutional Amendment Act of 1976, has provided for equal justice and free legal aid. And this is a directive principle of state policy, which means that the state shall make endeavors for providing equal justice and free legal aid to each and every citizen of the country. Later, in the year 1987, Legal Services Authorities Act 1987 was enacted and it came into force in the year 1995, and thus the Lok Adalats were given a constitutional status via means of this particular act in the coming situation. So basically, the motto or the purpose of this particular Legal Services Authorities Act 1987 was to provide free and competent legal services to weaker sections of the society, and to organize Lok Adalats to secure that the operation of the legal system promotes justice on a basis of equal opportunity. Thus, when we talk about the provision of free justice as well as legal aid that is free of cost for every person and specifically the weaker section of the society, it was the aim of the Legal Services Authorities Act that it shall be done in this situation. Also, it also provided that the Lok Adalats shall be there to secure this particular provision and to promote justice on the basis of equal opportunity. Now, let's understand that what is the purpose and also the various advantages which are attached with the Lok Adalats. Firstly, let's talk about the scope of Lok Adalats. So mostly the cases in these institutions are related to motor accident claims, disputes related to public utility services, cases related to dishonor of checks, and land, labor, and matrimonial dispute except divorce. So as we know that there is a divorce is taken up in the civil courts. Then if we talk about the advantages that are attached with the Lok Adalats, specifically, or the major advantages are, firstly, it is a party-driven process. Now, what do we mean by being a party-driven process? So here, both the parties, when they would agree with each other, only then the case would move forward in the Lok Adalat, which means that if I am in a dispute with some other person B, then not unless both of us agree to take this case to the Lok Adalat, this case would not be instituted. Thus, it is a party-driven process. So here, it also shows that the parties are themselves very, very much willing to gain justice, and so it makes the entire process even speedier and more, focused. Then it has a speedy disposal. Yes, of course, it was one of the purpose as well that Lok Adalats should be able to dispose of the cases in a speedy manner, and thus any delay of justice should not be allowed. Then the flexible procedure, which means that here CPC, CRPC, like the Civil Procedure Code, the Criminal Procedure Code, are not really used. Rather, other flexible procedures are used. In a way, we can understand that the main purpose of taking up a matter to the Lok Adalat is that we want a resolution. So rather than just bringing in some punitive conditions or some punishments for the other party, the main purpose is to seek justice for ourselves first. Then it is economical because there is no court fees attached whatsoever. Then the finality of awards, as we know that here whatever judgment is brought through the Lok Adalat, it has a power and value of like that a degree of a civil court. So which means that no appeal as such will be there from the judgment of the Lok Adalat. Yes, of course, if there is any grievance, a new and fresh trial can be of course taken up in the courts of law, but here this cannot be brought to an appeal, which means that there is finality of awards that are given by the Lok Adalats. Please do not get confused with the awards by any ceremonial prizes or something. In the legal language, awards means the judgment or whatever decision or judgment or decree has been brought up by a court or by a tribunal. Then the award is treated as a civil decree, as I just mentioned. But also there are a few disadvantages which are attached with this particular institution. First of all, it undermines the idea of justice, because many a times what happens is that people do not feel satisfied with the judgments that come out from the Lok Adalats, and thus it is believed that real justice cannot be imparted in some cases. And in many cases, compromises are sometimes imposed on the poor, which definitely should not be the case if at all we really want that the weaker section should be represented equally and should be given free and equal justice. Now, here is some relevant data which is associated with the disposal of the cases that have been taken up by the Lok Adalats in the recent years. So, according to the National Legal Services Authority data, in the year 2016 to 20, Lok Adalats disposed of approximately 51,46,415 cases. Then the National Lok Adalat, which was there on 8th Feb 2020, disposed of 11,99,575 cases. So in totality, from the years 2016 to 20, it disposed of 2.93 crore cases, which is significant. Then the average number of cases disposed per National Lok Adalat since 2017 has decreased, and that is why this article has been brought in today, that though at one time the complete number of cases disposed of by the National Lok Adalats would be seeming to be huge, but if we compare it from the previous data, then these cases have been decreasing in number, and thus this is highlighting the inefficiency that has been taken up by the Lok Adalats these days. So the first e-Adalat has disposed of 10.4 lakh cases till now. Then if we talk about the data which has been provided by the National Judicial Data Grid, 16.9% of the cases in district and taluka courts are 3 to 5 years old. So which means they have a pendency of about 3 to 5 years. Then about 20.4% of the cases in high courts are 5 to 10 years old, and 17% are 10 to 20 years old. So can you understand that what is the length of delay that has been taken up in the courts of law these days? And when we say that justice delayed is justice denied, it completely falls very much appropriate in such situations. And 66,000 cases are still pending in Supreme Court, 57 lakh in High Court, and 3 crore in the subordinate courts. So which approximately makes it like more than like approximately 4 lakh cases, which 4 crore cases which are pending in our courts. The next article talks about the transgender rights. So here it is something to be really happy and applaud about, that 13 members of the transgender community have recently been selected as constables under the Chhattisgarh Police. So after the 2014 ruling, Supreme Court ruling, Chhattisgarh also, firstly, constituted the third gender welfare board. Second, the instructions were issued to recognize them. And thirdly, district level committees were also constituted to identify members of the community. Now, here we need to take a moment and realize the fact that even though Chhattisgarh has huge problems that we recently discussed about the Naxalism, Maoism, and also the left wing extremism that we were actually talking about. And even in terms of education, in terms of growth and development and employment and various other things, Chhattisgarh is one of the states that is still lacking a lot of developmental aspects. But this is really something to be appreciated, that Chhattisgarh is so way forward, and it is taking proactive steps in providing transgenders the rights that they completely deserve. And in this direction, as we just discussed, Chhattisgarh government has constituted basically here the government has constituted third gender welfare board. Instructions were issued to recognize them, and district level committees were constituted to identify members of the community. Now here the significance of this step is that the transgender rights were not legally recognized before the Supreme Court ruling in the case of Nalsa versus Union of India in 2014, which was the National Legal Services Authority versus Union of India 2014. And then it was earlier the binary notion of gender denied equal protection of law to transgenders. So what happened was that before this particular judgment, in the legal terms as well, only two genders were recognized as such, the males and the females. And thus the transgenders were not given any rights, specifically any such official rights whatsoever. But this case, Nalsa versus Union of India 2014, has been a landmark judgment in this direction. So no reservation of the transgenders was there. They faced abuse, discrimination, and abandonment, and still a lot has to be done in the right direction. So if we talk about that, what are the specific conventions or laws in this direction? We have the Universal Declaration of Human Rights, which completely includes the transgenders and their rights. Then we have the Yogya Karta Principles of 2006 that also at a front talk about the rights to be provided to the transgenders. Then we have the Transgender Persons Protection of Rights Act 2019, which was inspired from the above. And this act recognizes that the transgender persons have a legal right to self perceived gender identity in accordance with the principle of psychological test and not biological test. Now, this means that whatever personality or whatever gender is perceived in the mind of a particular transgender person, that shall be the recognized gender of him or her, as in of that particular transgender person. So here it will not be the biological test that would be taken, rather it would be the psychological test that would be considered to understand the personality and to understand the gender identity of this particular transgender person. For example, there might be a person who is or who has a body of a male, but who he feels like being a female. So thus the biological test would say that the gender is male, but the psychological test would say that she is a female. So that is why for gender identity, this law provides, or this act provides, a legal right for that person to have the gender identity on the basis of psychological test and not biological test. With this, let's see what do we have in news and flash today. The production linked incentive scheme has been extended to ACs and solar panels, basically the white goods. So the Union Cabinet has approved the production-linked incentive schemes for white goods. Please consider these are the white goods. Now, what are the white goods? These are generally the electronic items, the large size electronic items, like we have the TV, we have fridge, etc., like ACs and LED lights, etc., and high efficiency solar photovoltaic modules. And thus now the manufacturing of these things will also be prompted in the country itself. Second, poppy cultivation. So the union government has decided to rope in the private sector to commence production of concentrated poppy straw from India's opium crop to boost the yield of alkaloids used for medical purposes and exports. And in India, the states of Rajasthan, Uttar Pradesh, and Madhya Pradesh specifically deal in the cultivation of opium. Now, please consider that this opium has to be cultivated legally, and there has to be a complete license which is given by the government for this cultivation. Thirdly, Reserve Bank of India monetary policy has in the April 2021 said it has kept the repo rate unchanged at 4% and also retained GDP growth projection for 2021 to 22 at 10.5%. Now by repo rate, we mean the interest rate at which the normal commercial banks get loans from the Reserve Bank of India. Just the way as we consumers get the loans from the banks at some specific interest rate, similarly, these banks also many a times take up loans from the RBI at some particular interest rate, and this interest rate is called as the repo rate. So currently, the Monetary Policy Committee has kept this repo rate unchanged at 4%. Also, it has introduced a new program called as the Government Securities Acquisition Program, GSAP, through which it will purchase government securities worth rupees 1 lakh crore. So this was all for the day. We hope it was a good and informative session for you all. Thank you so much for staying tuned with LawSeco. Please subscribe to our channels for such more updates to come.